homicide via intoxication, and the second for possession of drug paraphernalia. Both of those convictions should be reversed. First, both convictions should be reversed because
I do have a question.
Yes.
So there were two tests, right?
Yes.
And the first was allegedly that it was a voluntary.
Correct.
And the second one was the search warrant.
Correct.
Are you challenging the search warrant?
No, Your Honor. So
So if you're not challenging the search warrant, what difference does this make?
Okay, so both tests were introduced at trial, and they had different contents. So it's not as if the second result was different or was this exactly the same as the first.
.143 versus a .134?
Well, there is similar alcohol, but this first test was tested.
But that's all you need, right?
No,
Alcohol.
it's not all you need. It is all you possibly need for a conviction, but it's not all the state.
Wasn't she charged with per se?
No, she was just charged with vehicular homicide via
Well,
intoxication.
the instructions say if it's greater than a .08, right?
I'm not sure the instructions actually say that, but
You mean they gave the blood test results to the jury, and the jury was not given anything to reference whether or not the person was under the influence for purposes of vehicular homicide by intoxication? Is that what you're saying?
I'm not sure I'm understanding precisely what the question is then.
Okay, .08 or higher.
Correct.
That's an indication that somebody's under the influence, right?
It can be, yes.
For purposes of the vehicular homicide statute.
Correct.
And you're saying that the jury was not instructed about that?
I'm not sure. They probably were, but I can't recall precisely from.
.14 and .13 are a whole lot higher than .08, right?
They are, but that's not the end of the inquiry. So there were two.
I don't understand. What's the inquiry then?
Okay, so there are two tests. The first one from the consent, and then the second one from the search warrant.
Right.
So the second test shows the presence of alcohol, and it also shows the presence of marijuana and morphine. The first test does not have any indication of illegal narcotic use. It just has alcohol. So the state relied on a theory of intoxication via both alcohol and drug use. Secondly, they also sought a conviction for possession of drug paraphernalia. So the state's theory at trial was that Ms. Allen was under the influence of both drugs and alcohol at the time of the accident. So if its theory is the presence of drugs and alcohol in her system, if they don't have that first test, the one that was done by consent, then they lose a significant part of their case. They lose a significant part of their case as it relates to paraphernalia, and they lose a huge part of their case as it relates to intoxication. Could they have proceeded solely on alcohol in the blood? Sure, they could have, but they did not.
They could still proceed on the drugs. I mean, you have the cut straws, you have the prescription pills, you have, what's the other? Yeah, thank you. You have three items which the police officer testified to are drug paraphernalia. So it wasn't like they couldn't proceed on both the intoxication charge as well as the drug paraphernalia charge without that blood test. They could have easily proceeded on both of those.
But they did. They went forward with both tests at trial.
Right. So I think what we're saying is, what does it? It's harmless. I mean, at the end of the day, what does it matter if you're going to leave the warrant test in, which shows alcohol?
Yes.
And there is testimony from the police officer about the paraphernalia and the prescription drugs. Now, the jury may have said you didn't prove to us that she ingested the drugs, but there's proof they could go on both of those without the test, without the warrantless test. They could easily go on both of those charges without the warrantless test.
They may have been able to go forward without the first test, but they did go forward with it. So the state, the district attorney who's prosecuting this case thought, if I'm going to get a conviction on these two charges, I need to present both of these tests to the jury.
I understand what they did. I guess what we're trying to ask, and maybe we're not asking it well, is at the end of the day, what's it matter? It's harmless at the end of the day, because They could have proceeded and gotten convictions on both counts without the warrantless test. So even if we say you are 100% right, the warrantless test should have never been allowed, is it not harmless
It,
that it was allowed?
yes, it is harmful, and it's harmful on both counts. So there's 2 points to make. First, this is a constitutional error. So if the court's just agreeing that there was an error in the first place, it's a constitutional error. That means it's the state's burden to prove that this was harmless beyond a reasonable doubt. So the court's taking it as a given that this was harmless because, well, there's a second test that obviates the need for the first test. This really wouldn't have mattered. That's a far cry from the state carrying a burden to show beyond a reasonable doubt that this had no effect on anything. The reason we know this had an effect is because the state, the district attorneys who prosecuted this case, felt the need to use this test. It's not like this was not in dispute at trial. This was a heavily litigated issue that was subject of multiple pretrial motion hearings. And throughout that, the state maintained that they needed this first test to prove their case. If they felt that it was so obvious that the second test gets rid of the need for the first, then they didn't need to do this. But that they did shows that the attorneys who were able to look at the jury, able to look at the witnesses and see the problems maybe with the way this case was going to be presented, they decided, well, we need this. And if they felt that they needed it, then I don't think we can just assume, well, there was a second test, so what difference does it make on the first? Turning to like how that relates to the paraphernalia issue. So there was testimony from one of the officers that these items have been used apparently in the past as devices for consuming narcotics in some way. So there are a couple issues with that where it proved, or it shows that the state needed the results of this blood test to prove paraphernalia.
In a drug arrest to find these things, you know, then why wouldn't
How
that?
else would you prove it? I mean,
Well, okay.
I mean, in my experience as a trial judge, it was just, okay, we found these things. These things are commonly used to consume or ingest drugs in some way, and that's really all you have to prove under the statute.
I think if you look at the cases that have been cited in the briefs and generally how this comes up in other contexts and likely in the cases that Your Honor has seen and that certainly we've all seen, is that there's some other fact in addition to here are these objects
But it's
and
not required.
That's not an element under the
It's not required.
statute.
You don't have to have some other fact.
other fact, then I don't think it's enough for an officer just to stand up and say,
Well,
this bottle is drug
Maybe
paraphernalia.
if you had one cut drinking straw, but when you add to it the razor, a mortar and pestle, and you have pills, kind of hard, and you had the officer's testimony, I think it's kind of hard to say that that's not drug paraphernalia. Unless she's a compounding pharmacist, perhaps.
But that's taking her guilt as an assumption. And I don't think the state is permitted to do that under the statute when it is required to prove. And I understand Your Honor's point about, well, they just need to prove that this object exists. They have to prove under the statute that the object is intended for use as paraphernalia.
And they
so-
had
So if-
testimony to that effect, and the jury heard all of that and saw the exhibits and concluded that it was.
The only testimony they had was an officer saying these objects can be used as drug paraphernalia.
What other I mean,
Okay.
I've seen these in pleas, I've seen these in trials. I don't ever recall seeing any other evidence other than what's required under the statute.
Well, so the statute has a multi-factor test that goes
Yeah,
through,
it's got all these things that the
and
jury
none
can
of those
consider.
things are present here. That's the issue here. So frequently, there's something to the effect of, well, you find the drug paraphernalia sitting next to the actual narcotics. When you find that, well, that's evidence that this is going
well,
to be.
there were pills and there
were
was
pills
an
that didn't
order.
belong to her. I mean, that would be, I might tend to agree with you, though I don't know that I would, if they were her prescription pills, but they were prescription pills that they said did not belong to her. They didn't know who they belonged to, but they weren't written to her. So does that not tend to lead, especially when you have a razor and a straw? I mean, that was the officer's point, was typically what happens is people crush these up, divide them up with a razor, and use a straw to ingest them. Is that not enough?
The officer did not say that the pills that were found in the car, he frequently sees those being crushed up and ingested in that manner.
But he said pills. He didn't, I agree he didn't say those specific ones, but he said pills that, oh, by the way, were not prescribed to her, and these other items are typically how people ingest pills. And so why is that not enough?
Okay, again, I turn back to the factor test that's set out in the statute and this language from this court about what additional proof is required. So frequently it's an illegal object is found near the paraphernalia or the alleged.
So prescription drugs that didn't belong to her, that's illegal.
But was not charged in this case.
Doesn't matter whether it was charged or not, it's still not legal.
It does matter that it wasn't charged in this case because there's the assumption that it wasn't legal for her to have these. We don't know why she had these. We don't know why this pill container was in the car. In and of itself, it means very little. And since it wasn't charged and there was no evidence put on about, are these the sort of pills that get ingested in this manner? I don't know. And the reason I don't know is because the state decided not to put on that proof. It decided that the only thing it needed to do was say, well, these objects are sometimes used as drug paraphernalia. That by itself is not enough because it doesn't satisfy any of the other factors that are set out in the statute. So if we have all those factors that the jury is meant to consider, we need some kind of proof from the state related to those. Because otherwise, what the state is saying, well, we have these objects. Sometimes those objects are used to consume narcotics. That's it. We're done. If that were the case, then that multi-factor test set on the statute wouldn't be necessary. The cases from this court talking about what additional proof is required would not be necessary. The cases that talk about testing residue on the objects to see if they match the substance that was alleged to have been consumed, that wouldn't be necessary. So all of those additional bits of proof, those additional bits of evidence that the state is expected to put on are not present here.
Remind me, was there residue that was untested in this case? I don't remember.
So the state says in its brief that there is something you can see on the straw. I'm not sure if that's true, but there was nothing tested. And I don't know if we could.
What was the actual testimony?
I don't believe there was any
Yeah.
testimony about what
Okay.
was left on the straws or the razor or anything else. So that illustrates the point about if the state is going to charge this, there are a variety of things they can do to elicit proof that would meet their burden. They chose not to do that in this case. And this kind of circles back to why the suppression result matters. So to get to this being drug paraphernalia, one of the things that the state relied on was the positive drug test. So they test the blood for drugs, they find drugs, and they use that fact to support the paraphernalia conviction. If they don't get to use that blood test that came back positive for narcotics, they no longer have that additional fact. And then they are left with Miss Allen possessed 3 ordinary objects in her car. There is nothing illegal about having straws, nothing illegal about having razors, or a mortar-like object. I'm not sure it actually was.
But she had them in addition to pills that didn't belong to her.
That we know nothing about.
I know, but that's additional proof that the jury considered in weighing those factors.
Okay, I don't think the fact that there was some pill nearby is a factor that goes towards this being drug paraphernalia. I think we need something more direct from the officers about, okay, so this type of pill is frequently consumed in this manner, or this type of pill is used in that way. We don't know anything about these pills. We don't know anything about or how they were ingested typically. We don't know who they were prescribed
So
to.
if it
We
was
just
a-
know they
if
were
it-
there.
If it was a marijuana case, let's say, and it was paraphernalia dealing with marijuana, and the officer just simply testified, there was, in addition to these things we found, we also found in her purse a bag of a green leafy substance, and they never tested it. Could we convict her of paraphernalia in that situation?
So a quick question for the hypothetical, and I apologize for that. What is the nature of the object that's
I mean,
paraphernalia?
there's a bong, there's a roach clip, there's papers. I mean,
Oh,
you know, those things, something like that.
Okay, so those would go
Let's
directly,
just-
those would go directly to the factors that are
Okay,
illustrated
so
in the
let's just say
statute.
it's papers. I mean, people roll cigarettes.
Again, the factors in the statute illustrate why that might be paraphernalia, because how are those papers marketed? Are those papers marketed, rolling papers are marketed for the consumption of something you smoke? That is a factor that's listed in the statute as something the jury should consider.
So
when-
is the list in the statute exhaustive and limited to only that? Or can the courts look at other factors that the court sees? Hey, we tend to find this, or we tend to find that.
I don't think there is a catch-all that would quite allow something quite that broad in the statute, but I mean, I do think there is some level of, there's some level of generality within those factors that would allow the court to look, it's not strictly limited to what's listed there, but the point is that what is listed there should be something about at least one of those factors. And here we don't have anything related to that. Even in the state's response brief, it just relies on the factor related to there's no other ordinary use of these objects. There was no proof to establish anything like that at trial. So without some kind of proof about how these objects are used or what's their ordinary use, how are they marketed, how are they labeled, all of those things that the statute talks about, then we have a different case. But we don't have any of that here. The only thing we have is these objects are found, and here are these blood tests, that one of which shows the presence of narcotics, and from that you can conclude that she was using these objects as drug paraphernalia. But if you don't have that blood test, then we don't get there. Then all we're left with is she has straws in her car and a razor. There is nothing inherently incriminating about that. And in and of itself, that is not enough to sustain a conviction for possession of drug paraphernalia. But back to the original point about the suppression issue, since the court pivoted pretty quickly to the harmlessness, this mattered a great deal at trial. This case was not just about one positive drug or positive alcohol test where the state could get up and say, she's over 0.08, that's the end of the inquiry. The state did not do that. The state felt the need to put on proof about what else was in her blood. They felt the need to put on proof that she was under the influence of some kind of narcotic. And they felt the need to do this because they didn't think the alcohol was enough. And because of that, the trial court's error in denying the suppression caused harm, and it's harm that the state cannot prove beyond a reasonable doubt was harmless. And if the state can't meet that burden of proving that this was harmless beyond a reasonable doubt, then this case needs to go back for a new trial. And if it's so easy for the state to put on proof just through the second blood result, maybe they'll get the exact same result. But they need to do that. They need to put on the proof that it's admissible and get a conviction the right way. But otherwise, the court would be forgiving what is essentially blatantly unconstitutional behavior on the part of the police. With that, we'd ask the court to reverse, and I'll save the remainder of my time to the extent that I have any for rebuttal. Thank you.
Good morning, Your Honors. Abigail Renard for the state. This court should affirm the defendant's convictions for vehicular homicide and possession of drug paraphernalia. First, the totality of the circumstances demonstrated that the defendant voluntarily consented to the blood draw And even if this court disagrees, any error here was harmless. Second, when officers searched the defendant's car, they found a variety of pills, a small container resembling a mortar and pestle, a razor blade, and a straw that had been cut into 3 sections and stored in a credit card holder. Viewed in the light most favorable to the state, this evidence is sufficient to support the defendant's conviction for possession of drug paraphernalia. So first, addressing the suppression issue briefly and the merits of the suppression issue. Here, whether consent is voluntary is a question of fact that is to be determined by the totality of the circumstances, and the trial court properly analyzed the totality of the circumstances here. The officer testified that he had a cordial interaction with the defendant. They were in the hospital. He was the only officer there. There was no weapon, and the defendant agreed to a blood draw 3 times. She had been...
At no point in time did the officer advise her of the implied consent law. At no point in time did he explain anything other than, can I draw your blood for legal purposes? That's all he said to her.
That is correct, Your Honor.
And this is a woman who initially, when the officer arrived on the scene, the paramedics would not let him talk to her because she was so confused and this, that, and the other. He gets to the hospital. His first interaction with her, he even says, these are my words, but basically he even says she didn't know what was going on. He then, like 15 minutes later, goes in there and says, can I take your blood? And she says, yes. That's it. That's the entire interaction. How is that possibly sufficient to allow that to happen?
Because he also had observed her. He thought that she had become more coherent. He heard her talking to the nurse. She told the nurse her name. He had seen her interact. He asked her when the nurse was outside of the room, and she said yes. He brought the nurse in, and the nurse had also been, it was the nurse who had been treating her. And
so
then
she
the
knew
nurse
her
asked
name,
her.
but did she understand why he was drawing her blood? And more importantly, did she understand that she had the right to refuse to allow him to draw her blood?
By her own admission, yes, Your Honor. She testified at the suppression hearing that if someone had come into the hospital and told her they were going to draw her blood for legal reasons, she would have understood that she had the right to refuse. So by her own admission, she understood that. But again, this is all, to the extent that you all disagree and think that this is not enough, any error here is harmless because, as you discussed earlier, the defendant here, there was another blood draw, and the alcohol content in both blood draws was very similar. I believe it was 0.14 versus 0.13 perhaps. I don't remember the specific numbers. But to your point, Judge Montgomery, the jury instructions are not in the record, if I recall correctly. So it's not clear exactly how the jury was instructed on that. But I don't think it makes any difference because here, again, the alcohol content was so high. Viewed in the light most favorable to the state, obviously the defendant has not challenged the vehicular homicide sufficiency, but a jury could reasonably conclude, based on that blood alcohol content, that she would have been very intoxicated. And the jury could also look at all of the testimony about her being incoherent and mumbling and conclude that she was very intoxicated. There's ample evidence of impairment here. Any additional evidence from the consent blood draw as it relates to the vehicular homicide for sure is entirely cumulative.
Did the state in any form or fashion need the blood draw with the drug content in it to prove the first count of the indictment?
No, I don't believe so. And I don't think that it was necessary for the possession of drug paraphernalia charge either. Because, although sure, it could be helpful having the additional drug test results, but I don't think looking at to respond to counsel's argument, I don't think looking at it and saying, oh, the state felt like it needed to prove this in order to prove its case or needed to present this evidence. I don't think looking to that is quite the right way to look at the issue. You have to look at what the statute requires. And here, the state proved its case. I think it's important to look at for the factors that deal with the possession of drug paraphernalia and whether or not an object is drug paraphernalia. The opening of that statute directs the court to consider the factors, quote, in addition to all other logically relevant factors. This is not an exhaustive list, nor is it a required or determinative list of factors. And here, the jury could reasonably infer from the evidence that these objects were drug paraphernalia. The first officer testified that I believe he was inventorying her car or something of that nature, and he found this little credit card holder with the straws in it. And the straws are cut into 3 sections. It's stored in a credit card holder. When you look at the photographs, there's a photograph, I believe it's in Exhibit 6, that shows the inside of the straws, and it looks like there's some sort of white powder. To your point, Judge Ayers, I believe there's no testimony really about that. There was no testing done on that. But when you look at the photo, it's very apparent that there's some sort of white powder inside. And it's inside the straws, not outside the straws, which I think is also relevant. And he testified that in his experience, cut straws were indicative of narcotics use and could be used to ingest the drugs. And then the second officer also testified about those straws being commonly used to inhale powdery pills and substances. The officers also found a razor blade, a small container that it also appeared to have some sort of residue in it. It's not entirely clear, again, what that would be. There were no tests done. And then also the variety of pills in the car. And again, there was no testimony about what the pills were, but in the photographs, I believe in Exhibit 12 in the record, you can see that there is an opiate prescription for a man named Michael Griggs, not the defendant. And it was, the label is somewhat faded. It looks like it's for oxymorphone or something of that nature. The defendant had her own gabapentin prescription, and then there were loose pills also kind of throughout her car, throughout her purse. And then in addition to that, there was this drug test. But without the drug test, there's no real impact. There's no need to have the drug test in order to prove that these objects were drug paraphernalia and to support her conviction for possession of drug paraphernalia. The jury could look at this, viewed in the light most favorable to the state. This evidence is sufficient. To circle back to the motion to suppress, because the evidence is sufficient, any error in that was harmless. And if this court has no further questions, we ask that you affirm the defendant's convictions. Thank you.
Just a couple of things real quickly. The test is not whether a jury could have concluded that the evidence was sufficient to support the first conviction without this blood test. That is simply not the test, and that's what the state is asking this court to rely on. The test is, for a constitutional error, is whether the state can establish, and the state has the burden to show beyond a reasonable doubt that this did not matter. That is entirely different from just a basic sufficiency test, which the state is now relying on. The state's saying, well, we could have proved this without this additional evidence. That might be true, and maybe on remand they'll be able to. But that's not the test for examining whether a constitutional error is harmless. The state has to prove it beyond a reasonable doubt, and they have failed to do so.
So the state introduced testimony that there was blood alcohol content from a warrant that's not being challenged, that's above the legal limit.
Correct.
And the jury is instructed on this, that intoxication is, and I just looked at it's in here, is either drugs or it's alcohol of 0.08 or greater.
Okay.
How is that not beyond a reasonable doubt that it didn't affect that count?
The reason we know it affected that count is because the state relied on it and insisted upon it being part of the proof of intoxication. If the state believed that the only thing they needed was alcohol, they could have done that. They could have tried to get a conviction on that, but they wanted to do all of these things together because it allowed the state to paint a different picture of Ms. Allen than they would have been able to paint had they only had the blood test from the results from the second blood test. This affected the state's trial strategy and how they presented this case to the jury. That has an effect. And the state's insistence on relying on it throughout had an effect on both counts. And because the state did that, we can't just say, well, they could have done this a different way. That's almost always going to be true whenever there's a bit of evidence that isn't completely doing away with the state's case. There's always going to be something else that the state could have presented, and maybe they could have gotten a conviction with that. But that's not the test. Just because they could have gotten a conviction without the first blood test doesn't mean that everything that flows from the unconstitutional search is acceptable. And so for the reasons outlined at the beginning and in the brief, we'd ask this court to reverse and remand for a new trial on count 1 and reverse on count 2. Thank you.
All right, that concludes the morning docket. We'll be in recess for the morning docket, but I'm not a Middle Tennessee person, but who's kind of with the group that can kind of tell me who all we have here?